kick it off?
I do. Go ahead and take it from here.
Awesome. Well, hi, everybody. I'm Todd Atlas. I'm the president of EO Raleigh-Durham, and welcome to our fifth, I believe, virtual learning event out of our series we're calling Coronavirus in Your Business. We have an awesome session for you today. It's some wonderful things coming up. For the future, we're going to be hosting these Thursdays at 2 p.m. over the coming weeks. Amy Henning, our chapter administrator, and Matt Zeman, our learning chair, have been absolutely amazing putting these things together. And I want to thank Olivia at EO Global, who's helped get the word out there. It's amazing to see people from far reaches of the world join these calls. What started out as just a way to connect with our chapter in light of canceling all of our learning events and kind of in-person socials has turned out to have a lot more interest in. It's been really rewarding to put these together. Matt would love you to be as interactive as possible, so we will open these up for more of a kind of interactive conversation with questions. And I will also put my email and Matt's email in the chat. So if you have suggestions, please send them to us kind of for future content. Before we get going, the events we have coming up next Thursday, Scaling Down Your Business. We have 3 EO members talk about actual things they've done to scale down, and it'll be a nice kind of QA and kind of experience share. The following Thursday, April 16th, we have Dr. Tina LePage, clinical therapist. She'll be hosting critical stress management skills for leaders during national crisis. I will be needing that thoroughly. She's going to give us specific advice on how to manage our stress and help our employees and family manage their stress as well during this time. April 23rd, how we will science our way out of the coronavirus pandemic. Dr. Giles Shea will be hosting a panel of experts to explore what we know about it from a scientific perspective and cover simple and practical ways to protect yourself and your family and discuss how the various scientists, innovators, and businesses are coming together to fight it. And then finally, April 30th, how to increase your bottom line during tumultuous times and emerge stronger. Brian Smith from Culture Index is going to be discussing how they utilize applied behavioral analytics to identify and measure employee capability and productivity to put the right people in the right seats and immediately kind of recapture some of the money lost to employee disengagement. So lots of amazing things coming up. But for today, we've got turnaround and survival strategies from a corporate finance and legal perspective. Kenneth Marks will be sharing principles he's learned from both his own experience. He has operating company, he's a YPO member, and as an advisor helping others right their ship. Longtime huge EO Raleigh-Durham supporter as well, Tad VanDusen and a couple others from Williams Mullen will co-present, providing experience from a turnaround, corporate finance and strategy side, coupled with their legal perspective. So I'll turn things over to Matt. You've heard enough from me. Really looking forward to enjoying as a participant.
Thanks, Todd. Just have a couple of housekeeping items for everybody. Everyone is muted right now. So if you have a question, please post it in the Q&A section or just raise your hand. There's a little button to do that and we can call on you. If you have the same question as someone else, please post hit the thumbs up button and that'll upload it. And then we will know that's more important than other questions. And again, we're going to unmute you a little bit later in the call so that you can ask your questions directly if that's what you would like to do. Today's webinar is being recorded and will be shared afterwards, so please don't say anything here that you wish to keep confidential. We're going to be sharing the deck that we're going to be going over and contact information for Tad and Kenneth at our website, which is eoraleigh.com/coronavirus, and we'll post that in the chat. And with all that said, I'm going to step back and I think turn it over to Kenneth Marks to kick this off.
Thank you, Matt. I really appreciate it. Appreciate everybody joining today. We both, I know for Williams Mullins and for High Rock Partners, our firms, we've both been involved with EO and early on with the founding of the EO chapter for many years, and just excited to be a part of this. As I've in kind of the spirit of the EO spirit. Please take what we say as our experience and our ideas. You know, you have to apply these things specifically to your own company, and they have to be tailored to what really makes sense for you. But hopefully, we're going to share some things here from our experiences that might be valuable for you as you're continuing to navigate kind of the tumultuous time that we're in. I think we'll be able to leverage and kind of take off from Randy Nelson's presentation last week, particularly where Randy was talking about creating target budgets and a transition plan. We're gonna hit that and kind of connect the dots to a high level kind of crisis management response, almost turnaround plan, and maybe some ideas that'll be helpful here, both from a corporate finance and from a legal perspective. As Matt said, we're going to make the slides available afterwards. There's a lot of content here, and not expecting that you'll have notes or that we'll cover everything, but we'll send it along afterwards, so you've got a version of it. Matt, I'm ready to go to the next if you want to. And kind of the overview, let's just go ahead and skip to the next slide, so the one with perfect. So for those of you that have ever been through a turnaround or had to deal with crisis management, there's kind of a classic framework for how to think about it. And it's a 7-step process. It starts with crisis stabilization. So I think a lot of our discussion today is going to deal with a 60, 90, 120-day window, which is how do we stabilize the business today so that gives us runway and time to really think about recovering based on what happens here in the business community over the next quarter or so. This idea, what do you mean by crisis stabilization? What we're really talking about is how do we have enough cash flow to make it through this period, to make good strategic decisions and to be in a position to recover and to kind of regain some steady state or predictable operations. So that's kind of the idea. And buckets 1, I'm calling them buckets, at the beginning, crisis stabilization 1, 2, and 3, where you get the stakeholder support. One of the things you're going to hear about it that's really important is communication. Probably heard it before, and you'll continue here. Communication with your stakeholders, whether it's your shareholders, your employees, your customers, your suppliers, your partners. It's all really important at this time to manage expectations. So, and in a worst case, to stay out of bankruptcy, to be very candid with you, in a lot of instances where we're having this kind of conversation, leadership has done something wrong or something's happened to the business that it wasn't planned for, and you kind of get into who's the right team to move forward and things like that. Right now, we're not really thinking about it like that. We're thinking about it, look, we all have been pushed into this situation here in the U.S., and how do we manage our cash and our liquidity over the next 60, 90, 120 days so that hopefully as things recover, we're able to then afford to and have a game plan to go forward. So part of this is I've got it there as a highlight, prioritizing the kind of the critical path to a recovery. So Matt, let's go to the next slide, if you will, for a second. And so what I wanted to do on behalf at High Rock Partners, my business partner, Buddy Howard, and I have kind of put together some concepts from things we've learned and want to just share a few highlights of that. One is that you need a tool to make decisions by. And in a second, I've got a chart, a slide that shows what we consider a 13-week rolling cash flow forecast, which is a tool that really should help you from a decision standpoint as you're thinking about making financial commitments and cash disbursement commitments here in the months ahead. So before we dive into that, I want to give you a couple ideas on prioritization of cash. As I had mentioned just a second ago, in a traditional turnaround sense, the backdrop of that thinking, it has to do with bankruptcy law. And what you'll find is as you're thinking about this, it's not always intuitive to the growth mindset that many of us have in building our companies. So I want to point out a couple of thoughts that aren't counterintuitive. One of those is the very first bullet, which talks about making cash disbursements or payment decisions based on if you're putting cash out, how is that employee, partner, supplier relationship helping us move positively to a recovery phase. And if you're using cash or dispersing cash, it needs to be cash that's going to generate more positive cash flow. And you say, well, of course it is, right? Well, let me give you an example. And this is where it starts to get tricky, is paying your bank or paying for capital leases. They don't really create positive cash flow for you in the short run generally. So that says, well, oh, wait a minute, should I be making long-term debt payments right now? Is there a way to maybe not have to do that? But you need to think about that with every resource around you, every supplier, every relationship, because cash, what we're trying to do in this phase of stabilization is preserve cash and have cash available that we can use to navigate through the next several months. So cash that's coming in is to be used for helping us get through this phase, this crisis stabilization. As I mentioned, communication, you have to make decisions and you have to communicate those. You need to do what you say you're going to do. If you find that you made some decisions that you can't do what you say you're going to do, you got to be in front of them. You communicate to whoever those parties are and reset those expectations. And then lastly, just as a thought here, it's a little bit of a soft thing, but having been through this a few times, one of the things you're going to find is that there are some people that aren't going to be very happy to work with you and are really going to start with some kind of personal attacks. And you have to kind of separate in your mind that the situation that you're in, and if it's a distressed situation, either mildly distressed or significantly distressed, it's not because of something you've done, and so you need to depersonalize it, it's not a personal attack, and because those things over time can really wear you down. And one of the things you don't want to be doing is responding to the squeaky wheel. That's a natural inclination in a situation like this, but it's usually not the right one. You want to be responding strategically and using your cash to move yourself through the process, not to be reactive to who is knocking on the door the loudest. Matt, before I move, let me do a quick question. Tad, anything here that I'm missing, or that just before I move the next couple slides?
No, I think you're particularly addressing communications with stakeholders, and staying out front of it and being transparent is critically important to build trust and for them to give you leeway.
Awesome. You guys jump in if there's something I missed. Here's a snapshot of a 13-week rolling cash flow. I'm not going to spend time on it. If there are those that want to need a template like this or want to spend some time and we need to set up a separate session or a phone call, glad to do that. The concept, though, is that you have a very tactical cash flow plan that is updated real time every week. And you'll see that we have a black section, which is kind of the summary of the cash flow, the in, the out, the kind of the net balance for the week. And then you'll see in the green section, that's actual sources of cash by customer, by week, what's coming in. And then, we talk about who owns those actual receipts and those amounts. And the same thing on disbursements in the red section below is by every lender, every supplier, every partner, how much money have we committed in what week, in what amount, and so that you know what you've committed to, and then you track it real time every week with actuals and forecasts. You roll it forward, and it gives you visibility as to what I can commit to, how long do I have till I have a real problem, and it's a great tool to communicate with your bank. So it's very tactical. Let's go ahead, Matt, to the next one. Buddy and I put together kind of a short list of areas that you might want to think about from a working capital standpoint. I'm not going to go through all of them, just to be fair from a time standpoint, but conceptually what we are trying to do is accelerate cash in so we have cash to manage through this period, and try to delay payments, delay cash out until we have a sustainable kind of get back to a perpetual or the ability to predictably be in business and predictably manage our cash flow on a longer term basis. And so the areas that you really want to look at, obviously receivables and how you manage those and what your strategy is around those. If for those of you that have inventory, what do you need from an inventory perspective, and how do you get what you need to operate without overcommitting? Accounts payable, for many, that's a big area, and how do you manage and extend those relationships, get the most out of them? And then if we flip over to the next page, thinking about credit facilities, trying to be ahead in stress testing covenants, so you know if you're going to be in breach, if you can foresee it, and you can have a discussion with your lenders, and talk, kind of getting in front of. So we're trying to be proactive in this. And then lastly, we're going to talk about funding. With existing lines of credit, do you have the option right now to increase those lines based on either collateral or a longer term plan? And then I'm going to hand over to Tad and do a segue here where we're going to talk a little bit about the stimulus funding, kind of an update what's happening. I know we had an SBA discussion a couple of weeks ago. There's a lot happened in the last 2 weeks. And so this will be a good segue now into some of the legal issues and the opportunities for funding. Anything else, guys, before I sign off here? Tad, I guess you should take it away.
All right, thanks, Kenneth. I'm Tad VanDusen. I'm a partner in the Raleigh office at Williams Mullen, and as was discussed earlier, we're also a longtime sponsor of this chapter of EO, probably since inception or very close to it. I'm co-presenting today with my partners, Ron Rogers, who's got a deep experience in the debtor-creditor area, and Mike Lord, who's a subject matter expert in employment law. And we're going to cover a bunch of areas related to bringing in cash, the legal tools you can use to bring in cash, particularly with the stimulus funding, as well as ways to minimize cash outflow with a focus on the 60 to 90 day time horizon. The idea being we're trying to get through, we're trying to survive until things hopefully normalize. So we're going to talk about tax, we're going to talk about loans, we're going to talk a little bit about contracts, some about creditor issues, and some employment parameters, all in connection with cash flow issues. Matt? First, I want to talk about the major important federal actions in the area of tax. The Department of the Treasury has broadly deferred the tax payment and filing obligations of business, particularly with regard to their obligations for 2019. Filings and payments aren't due now until, without penalty, mind you, until July 15th. The deferral of these obligations is really quite broad. And not only does it include income tax payments, it includes payments on self-employment income. It applies to individuals, partnerships, LLCs, and corporations. It also extends to first quarter 2020 estimated tax payments, and extends to IRA contributions, HSA contributions, and retirement plan contributions. When you consider all of those together, those represent significant cash outlays that get deferred for over 90 days and hopefully provide some meaningful breathing room to your business. You also have an opportunity, should you so elect, to defer the employer portion of payroll taxes that come due between about now and the end of 2020. That deferral will be effective until the end of 2021, when you have to repay 50% of it, and 2022, 12/31/2022, when you have to repay the second 50% of that. I will note that you are not allowed to elect that deferral of the employer portion of payroll taxes if you take advantage of the payroll protection loans that we're going to talk about in a minute. And finally, I want to, for those of you who are located in North Carolina, I want to mention that just as the feds have done, North Carolina has extended filing and payment deadlines until July 15th for individual, corporate, franchise tax, sales and use, and withholding taxes. So those are parallel, meaning that there will be no penalties assessed on those payments made between, after April 15th and July 15th. I will note, however, that in North Carolina by law, interest accrues on payments that you don't make after their due date. The legislature is not in session, but there is some informal conversation going on about changing the law to negate the accrual of interest in the meantime, at least on a temporary basis. But since the legislature isn't in session, we'll have to wait to see if they do change the law. Matt? So last week, there was a fabulous presentation on the SBA's Economic Injury Disaster Loan Program. I am not going to belabor a lot of the points that were made. It was a great presentation and went into a lot of detail. It was quite granular. What I do want to do, however, is just highlight some developments that have occurred in the last week and a half since that program was given. Since a week ago Monday, the SBA has agreed to waive its other available sources of credit rule. That rule says that you're not eligible for a disaster loan if you have other available sources of credit. Now that is no longer the case. So if you do, you can have other available sources. You can now still apply for a disaster loan. Second point I want to make here is that since last Monday, the interest rate has really come into focus. Our sources in the banking community tell us that the interest rate on these loans, both in North Carolina and Virginia, is probably going to be in the vicinity of about 3.75%, which is a very favorable rate. Finally, while these disaster loans are obviously meant to help make you whole as a result of a disaster, please know that this is not going to be an immediate fix or palliative. We're being told that the processing time from application through underwriting and disbursement is anywhere between 30 and 40 days. So you're going to need some time between now and actually getting the loan to be able to keep operating. Matt? So the second loan program that's particularly important and that I'm sure all of you have heard a lot about from your lawyers, your accountants, your consultants, your bankers, is the Paycheck Protection Program that was contained in the CARES Act. There's good reason for a lot of attention to be paid for this, because with respect to most businesses, this is a no-brainer. You should participate if you're at all interested in maintaining your employee base, certainly over the next 60 days. So what's involved here? Eligibility. Basically, all businesses with less than 500 employees are eligible to participate, including 501c3s, but not 501c6s, sole proprietorships, and independent contractors. This, unlike the disaster loan program, is administered by banks, not the SBA. You can apply for this starting tomorrow for businesses. If you're independent contractors, you have to wait until a week from tomorrow to apply. In any event, I would get on the phone with your bank if you haven't already and let them know that you're interested in pursuing this program, and make sure that you're on their radar screen. What the loan is going to entail is a loan to cover your payroll costs, which is broadly defined to include salaries and wages, vacation and FMLA payments, state compensation taxes, health benefits, and retirement benefits. So it's fairly generous. You have to apply before June 30th of 2020. The maximum loan amount is going to be 2.5 times that average monthly payroll cost as defined above that you incurred during the previous 12 months. Now, interestingly, proceeds of these loans can be used to cover not only those payroll costs, but they can also cover rent, utilities, and interest on certain other debt that your company may have. The term of these loans is going to be 2 years, and the interest rate is a really low 0.5 percentage point. You're not going to have to make payments on these loans for 6 months. Interest will accrue during that period. Next slide, please. And if all of that is not good enough, the program is really, really attractive because no collateral is required, nor are any personal guarantees required. And at the end of the day, your loan is going to be forgiven for all the payroll costs that you're able to document that you paid during the first week after you received the loan proceeds. And if that loan is totally forgiven, your debt is going to be canceled, which means it will not be included in gross income and therefore will not be taxable. I will note, however, that the amount of forgiveness that you will receive will be reduced if you reduce headcount during the 8-week period, or if you reduce the salary of any employee by more than 25%. Finally, the last item I want to touch on is whether or not you're an essential business. In North Carolina, the stay-at-home orders have been in place for less than a week. They went into effect statewide at 5 o'clock last Monday, and in Wake County last Friday at 5 p.m. There's a list in each of those orders of what constitute essential businesses, and actually the list is quite long. However, there is always room for gray area. And if you believe, after looking at that order and the list of essential businesses, that you're either not expressly covered or that you may fall into a gray area, we strongly advise that you contact the applicable authority, find out what the procedures are to request whether or not you can be categorized as an essential business, so you can actually continue operating at a greater capacity than you may currently be, and continue generating some revenue. So that concludes my part of this program. I'm going to turn it over now to Ron Rogers, who's going to do a couple of slides on contracts and creditor issues. Ron?
Thank you, Ted. In the 5 minutes or so that I've been allotted, I'd like to touch on 2 topics. First, your existing contracts with other parties, and second, on your existing loan contracts with banks and other lending institutions. Turning first to your contracts generally, of course, in the good times, not so long ago, your landlord, your vendors, your suppliers, the other counterparties of your contracts, they were performing to expectations, and there was little reason for you to consult the underlying paper, the documents, legal documents. Of course, these are not the good times any longer, and I'm telling you, the time is now for you to dust off those contract documents and review them. Most contracts contain several provisions that we call boilerplate. These are the provisions that are not negotiated, they're not business terms, they usually don't say anything specifically about the transaction. They're more or less dropped in there, typically at the end of the contract, but they may appear anywhere. And the one that I want to focus on is the force majeure provision. Now, I'm told that force majeure is French for superior strength. If you see a contract provision that uses the term act of God, act of nature, or similar language, you're probably looking at a force majeure provision. Purpose of the force majeure provision is to assign the risk of the occurrence of an uncontrollable, unforeseen event to one of the contracting parties. For example, many leases, commercial leases, will have a provision that says in the event of an act of nature, an unforeseen event, that the risk of that occurring is assigned to the tenant, at least with respect to the obligation to pay rent. In other words, if there's a natural event or hurricane, whatever it might be, that doesn't relieve the tenant contractually from its obligation to pay rent. Review your contracts to see if they have those force majeure provisions lurking in them. Become familiar with them and see if they give you any grounds to approach the counterparty to seek some relief from provisions that or the contract generally because of current circumstances. Another reason to look at them now is don't be surprised if your counterparty isn't doing the same thing. That is, reviewing those contracts and looking for ammunition that they might come to see you about. Now, I'd like to, so enough said on that. If you, Matt, could go to the next slide, please. I'd like to spend just a minute on your existing loans with banks and other lending institutions. Tad has already discussed certain facets of the CARES Act that was passed into law last week. I want to highlight Section 4013 of the CARES Act. Now, your banks are heavily regulated entities, and they are required to work with their regulators, report things. I won't go into depth on this, but they have sometimes, and with a problem loan, they've got to set up reserves. I'm sure you've heard your banks contacts talk about that. What that has the effect of doing, of course, is when there's a problem loan, banks have to be mindful of that, and it limits their flexibility. The good news is Section 4013 of the CARES Act releases the lenders from those restrictions to some extent, gives them greater flexibility to negotiate with borrowers to implement short-term forbearance agreements and loan modifications agreements. Now, I would underscore that it gives them the flexibility to do it. It does not mean the bank actually has to do anything, but I am seeing lenders offering, when asked, to enter into short-term loan agreements whereby monthly installments of principal and interest are deferred, tacked on to the end of the loan. There may be other accommodations that lenders will give when the regulations are promulgated and folks get a better lay of the land. But I would encourage you, if you haven't already done so, to get in touch with your lender and see if you can't negotiate some type of a short-term suspension of debt repayment. They probably have a form. It's probably a page long. It doesn't involve a whole lot of effort, and it gives you some relief over the next 60 or perhaps 90 days. And then there's also a bullet here. I won't go into it, but review your existing loan documents, identify trouble spots, notice requirements. If you're selling assets to perhaps raise some capital, make sure the lender doesn't have a lien on that collateral or on that asset and doesn't have to be notified in advance, or if they do, confirm with them before you sell the assets. And then I would just close with an observation before I hand this off to Mike. There's been discussion about having a dialogue with the counterparties, your lenders. Obviously, I encourage that. I would just say be mindful of written communications that you send. The current climate, everyone's trying to work together, but once an email is sent or a document is sent, it's out there. So just give some thought to, if you're writing something, composing something, just think about whether that you need to get into the level of detail that perhaps you've put in that communication. I would generally try to avoid making blanket statements like I'm insolvent or something like that. Obviously, situations vary, but I would just close with that observation. And Mike, I'm going to hand it off to you now.
Thanks, Ron. Again, my name is Mike Lord. I am your last speaker and perhaps the least. I have this one slide to walk through with you, and here's where we're going to chat about a situation that, for whatever reason, you can't keep payroll constant. There are many different ways to reduce payroll. You may want to consider taking a combination of these options so they're not exclusive and they all don't need to be taken. The first couple of bullet points here talks about reducing hours and or reducing wages. As our other speakers have addressed, Communication is key, especially clear communication when it deals with reducing hours or reducing wages. The most important piece of information to share with folks about this is that it's a temporary measure. It's not permanent. We're going to get through this crisis, and one means to get through it is to reduce hours, reduce wages. The other point of communication, I just want to state the obvious. Remember your audience. I'm assuming that we're talking about an at-will workforce. Remember, all that you can do is offer to reduce wages or reduce hours. The person you're making an offer to doesn't have to accept it. They can decline. So you can lose talent simply by reducing their hours or reducing their wages. So you need to strike a balance between how many hours are going to be reduced and how much the wages are going to be dropped. Understand that you may not have a whole lot of flexibility in that calculation, but just remember to try to strike the right balance. As a workaround, you may also consider a stay bonus. So you can try to make up for the lost wages or the lost hours down the road. So that is a creative option that may be available to you. As far as the specific bullet points of reducing the hours, you see that I've laid them out in two classes of people. First is non-exempt employees. That's fairly simple. You only pay for the hours worked. If you're going to reduce hours of non-exempt folks, you tell them in writing 24 hours in advance, and you can drop the wages as long as they don't go below minimum wage. The second bullet point deals with exempt employees. The problem here is that when you fool around with exempt employees' work week or their salary, you run into a big hurdle of, are you going to destroy the exemption? If you destroy the exemption, it's not just for that one particular employee, it's for the whole class of exempt employees, and you could be looking at a huge overtime bill. So you want to be clear with them and follow the same steps. You would tell these folks in writing 24 hours in advance of what reduction would be made to their salary. Their salary can't drop below $684 a week. Otherwise, again, you have this flexibility to negotiate with these folks about what to do. The third bullet point talks about volunteers. There may be people who are willing to step up and say that they won't work a portion of the work week. That's fine. And you're able to take salary deductions made for one or more full days of missed work. You can't do it half days. It has to be a full day of missed work. The problem, of course, is that people may have different recollections down the road about whether this was voluntary or not. So the lawyer in me recommends that you have an agreement that says this is voluntary and I'm going to do this until I tell you otherwise. But for your purposes, you can't really plan on X number of volunteers coming forward each and every week. I just simply included this just so you know that it is an option. The next two bullet points deal with layoffs and furloughs. Now, a lot of people use those terms interchangeably. The problem is that they have really technical differences to them. A layoff is the end of employment. Think of it as termination. Furlough is a situation where you carry on the employee on the payroll and they're eligible for benefits. And so you'd have to administer the benefits during the furlough. Don't worry that you're stuck into one path or the other. You can have a furlough and it ultimately does become a layoff. But just understand the differences between a layoff, permanent end of employment, where you'd have to re-onboard these folks, basically rehire them, and furloughs is where you carry them on. And your biggest concern there is benefits. Are these folks who you're carrying on entitled to benefits? You have to look at the benefit plan to see if they are eligible. Many plans say that you have to be an active employee doing X amount of hours of work before they're eligible for the benefits. So you don't want to get someone's expectations up that they're on furlough, but then tell them, so sorry, you're not eligible for benefits. The next couple of bullet points deal with benefits. Many benefits you have some control over, and the benefit here would be, say, a subsidy to go to the fitness club. Certainly that doesn't have any traction these days, but this is a situation where you can turn off the benefit on a prospective basis and saying this is a cost-cutting measure, again, temporary, we may revise it later on. The next bullet point gets to a situation where you go to, say, a 3 or a 4 day work week, but then the employee comes back and says, I want to take my PTO for days 4 and 5, the days that I'm not working. That certainly doesn't get you the cost savings that you were looking for. So you'd want to check to see if you have the flexibility in your PTO program to manage that benefit. In other words, say when you can use that PTO. And you may want to put a freeze on PTO use during this crisis. If that's not available to you, you'd certainly want to try to revise your policies to allow that to happen. But as you can see, that there are some creative ways to manage your payroll, but at the same time, that there's also some legal hurdles to that. So you have to proceed cautiously. Thank you.
Awesome.
So those are some great content. There's a bunch of questions here, Kenneth, Tad, Mike, Roger. Should we go to some questions, or do you have more content?
No, I think we're happy to go to questions.
Yep.
Well, let's then kick this off with Alexander, who is out of the Richmond chapter. I'm going to unmute him right now. And Alexander, oops, sorry, I'm going to try again. You can go ahead and ask your question.
Yes, hello, can you hear me?
Yes, I can.
Okay, great. So I'll be direct so I don't waste time. My question is, I have multiple businesses, and some of them have employees and some don't. But there is a talk about the business owner compensation, and the ones that don't have employees but are on K-1s. Is anybody clear on whether the K-1 income can be considered as self-employment income and applied for in the PPP application?
So I don't know the definitive answer to that question, but it seems to me from the guidance that I've seen that you should apply for it, and my sense is that it will be covered. But I think when you're filling out the application for PPP, which is very simple and 2 pages long, I think you can have a conversation with the bank, and they can give you a definitive answer to that.
Okay, thank you. If I could just follow-up question real quick, as far as the different businesses applying as different businesses but same ownership, do you feel like there might be a conflict there, or it's different businesses so it should be acceptable?
So I think what you're talking about there, Alexander, are the affiliation rules, and Treasury issued some guidance at the end of the day, not yesterday, but the day before, where with regard to the PPP loan, they waived the affiliation rules on a very limited basis. And they're only waiving them with regard to businesses who are in the hotel and food services industries, specific franchises in the SBA directory, and those that receive financial assistance from SBICs. So otherwise, that means that the affiliation rules do apply, and that may limit eligibility for the PPP loan depending on how many employees, fall into the affiliated basket, if you will.
The question is not about affiliated businesses that are in the same industry. My situation specifically is one is a construction business and another one is a real estate holding business and sales. So they're not really the same employees or the same business at all, just same ownership. But
So you will have to disclose that there is common ownership there, but they are separate businesses. So I would complete a separate application for each business.
thank you very much.
Thank you. Paul Levering from the Raleigh-Durham chapter has a question. Is it a good, and I'm going to ask it for him, is it a good idea to apply for both the EIDL and the PPP?
Paul, it depends on your need. It's not an either or proposition. So the PPP is, as I said, I think it's a no-brainer. Because in all likelihood, it's gonna enable you to hold on to your employees, and you're gonna be able to get what is in effect a tax-free loan and a cost-free loan to keep them on and avoid the cost of rehiring once we get out of the crisis situation. As far as the economic disaster loan is concerned, the interest rates are pretty low. There will be collateral requirements, and if you have existing loans with your business, you're going to need to talk to your bank and see and look at your loan documents, as Ron said, to evaluate whether there are covenants that often do prohibit additional debt without consent. But I think it's a question of need, and certainly the cost of it is very reasonable under the circumstances.
So, question from both Raleigh and South Florida: what if someone does agree not to work and says, "Okay, I'm going to step off. You need to save some money. I'm not going to work." Can I provide them benefits even if they're not working? And if so, for how long? And I guess part two of that is then to Ron's question earlier. Does then that become a precedent that becomes company-wide moving forward?
This is Mike Lord. The first part that I'd like to address is someone saying they don't want to draw a salary or take pay. And I understand in the question that they weren't going to work, but I just want to underscore that. You can't, in private companies, have a situation where someone donates their time. If you suffer their work, meaning that they do something for you, you must pay them. You must pay them what you promised to pay them, or at least the minimum wage, or whatever the salary was. So we can't have, quote, volunteers in private workplace. The next question dealt with benefits. The answer to that question is going to be in the benefit plan itself. The benefit plan itself is going to describe who is eligible. One of the eligibility requirements may be that the person has to be an active employee, and it may define what an active employee is by the number of hours worked per week. Those plans vary considerably, so that's the best answer that I can give there. As far as precedent, I understand the concern there. I think the reality of the situation is that this is a unique crisis, and what we do here, I think we always frame in the context. This is a temporary, this is an extraordinary measure, and through that type of communication, leave it without a doubt that this isn't our company policy. This is an exception for these exceptional times.
So Mike, I'll do a follow-up on that. If assuming that a company has a traditional kind of boilerplate benefits, you have to work 31 or more hours, blah, blah, blah. Do they have the option here on April 2nd to make a new policy, to amend their benefits policy and say, except in the case of force majeure or 30 days of whatever period, the company at their discretion can allow somebody on effectively what's administrative leave to receive benefits for a period not to exceed 90 days. Does a company have the option to do that?
Absolutely. Freedom of contract. So that the discussion needs to be taking place with the administrator or the carrier about the particular plan, outline for them where you want to land, and I'm sure that they're willing to try to sell you that service. It will be just a question of the cost. Is it something that you can bear?
Mike, this is Kenneth. Is it, are those individuals that get furloughed, or are they allowed to file for unemployment?
Yes. So one thing that is consistent, at least in North Carolina, and again, if it wasn't clear before, I'm a North Carolina licensed attorney, and I'm to speak just to my experience here in North Carolina. For a layoff, it's clear, yes, you'd be entitled to make a claim for unemployment benefits. The same thing with the furlough situation. You're placed on an unpaid leave, and so your hours have been reduced to such a level that you'd be eligible to apply for benefits, for unemployment benefits.
Okay.
Raleigh-Durham question, going back to your notion of managing benefits, specifically PTO, if you have a corporate policy that says use it or lose it for PTO, and you then, but it also says we can determine whether you can use it or not, and you start saying no to multiple people to use their PTO, is there any risk that you will have the obligation to pay it out later? If you had to terminate them at a later date.
Right. So you got a couple of things going on. You have the forfeiture clause, and you also have the control over the use. So you exercise that control and say, going forward, if you're not on the books, you can't use PTO for the next 2-3 weeks. Exceptional circumstances allowed. Say you do that, you end up not being able to move forward and having to lay off one of these folks. Under the policy, they have forfeited the PTO, and it's difficult. Doesn't make you feel good. Legally speaking, it's defensible.
Okay. Jake in Raleigh-Durham has heard a rumor that the SBA administrator will be at the White House press briefing this afternoon to announce a delay of the Payroll Protection Program loan until next Tuesday. Have you all heard anything about this?
I have not, but it wouldn't surprise me. The amount of interest in this program is off the charts. I think bankers are going completely insane trying to field all of these requests. So a 2 or 3 business day delay in accepting applications and processing them would not surprise me. But I can't say whether it's true or not.
Yeah, I heard from our bank that they are delayed a day already, so it wouldn't surprise me.
Paul has a question. He just dropped off. I think, let me see if he's going to log back in. Let me ask a different question. We have a couple chapter members who have sold a part of their business. So I'll give a specific example. A person up here in Raleigh-Durham had a 20-person company, sold, call it 12 of the employees as of the end of February, and now has an 8-person company. Those 8 people were with the company last year in April, and they're still with the company today. Can they file for PPP and compare the 8 from last year only to the 8 today? Or will they have to compare 20 from last year to 8 today, and therefore take and let's use 10 because it's an easier number, take a 50% reduction in what they're eligible for?
So I have a feeling that they're going to have to take into account the new average for the previous 12 months, and I have a feeling that they're going to get the loan for the lower number for dealing with the lower employee headcount.
I want to clarify what you're saying there, Tad, just so I understand. So you're saying that for 2019 they're going to have to use the 20 number. For 2020 they'll use the 10. And then they'll take the 50% penalty? Well,
so if you're talking about getting a PPP loan, is that what you're talking about?
That's what we're talking about in this particular question.
So it's not done by calendar year, it's done on previous 12 months. So if you have if you're looking, well, actually if your previous 12 months of operations encompassed all 20 employees, I think you would be getting a loan that covered payroll for 20 employees.
All right, I'm not doing a good job asking the question. Let me try one more time. So yes, I believe a person would be able to use the 20 for what they qualify for if they chose to go that direction. When then when they're going for the grant portion, the forgivable, they would only have 10 in calendar year 2020 that are on the books, which would look like they reduced their workforce by 50%, which would make the grant 50% less. What do they have the option of just saying, forgetting those other 12 employees because that business is gone, and just saying we had 10 last year, those same 10 are working this year. We only want the loan, what we're eligible for 10 times whatever, and we want the grant for the same 10.
So I don't think it's a situation that's adequately dealt with in the Treasury guidance, having read it, which is pretty sparse. But the issues, yes, you're going to have an issue with explaining whether or not you had a reduction in force, and in order to avoid the reduction in force and therefore the denial of forgiveness of the loan, it's probably the safer bet to get the loan on the basis of 8 to 10 employees, and then be able to obtain clearly full forgiveness with no indication that you've had a reduction in force.
Great. We'll pass that on. Paul, who has dropped off but has a question here, Raleigh-Durham chapter. The CARES Act mandates employees with under 500 FTEs give 80 hours of additional PTO. I'm sorry, employers give 80 hours of additional PTO for COVID-19 related PTO after April 1st. Is that correct? And can you give us any details about it? Like, how do you get reimbursed? Usually with under 50 FTEs, you're exempt from FMLA. Sorry, part 2 is usually you're exempt from FMLA if you're under 50 employees. How do you file for an exemption of this if the company wants to? 2 different questions.
I'm here.
Let me take the first question. Yes, there is a new federal law, the first one that requires paid sick leave. And generally speaking, the paid sick leave is available if you are been quarantined, your doctor quarantines you, that you need to care for a child because your child is at a school or some other kind of situation like that. It applies to all employers under 500. There is an option for what is called a small employer, 50 or less employees, to be exempt. That's a process. And the requirements to show is basically by having to pay up to 80 hours of sick leave, basically jeopardizes my operations going forward. So you can tell it's a fairly high threshold. Looking at it as a practical matter, you may burn up as much time, effort, cost, and if you go the legal route, legal fees, in what you're trying to save. So I want you to take a look at it that way, understanding that it's not going to be looked at favorably by the department and the result is uncertain. Balance that against, are you going to have these types of absences, and make a decision that way. But that's the new lay of the law right now, and it started April the 1st, so we are right under it. Your next question was about the expanded FMLA. That also applies to businesses with 1 employee up to 500. So the folks who have been dealing with the FMLA know what the drill is, but now other folks who were smaller and exempt under the old FMLA are going to have to get up to speed on how to administer this new benefit. And the new benefit is paid. How do you get, and so that's money out of your pocket. You get it at the back end through some kind of reimbursement credit by filing information with the IRS. And so you front it, the government reimburses you. In very, very simplistic terms, that's how it works.
I heard something about that it was refundable through payroll tax deferral or something like that, but correct. I appreciate the answer.
Perfect. That sounded like Paul. Is that you, Paul?
Yeah, that's me. Somehow I got made a panelist. How you doing?
Hey, look at that. I was wondering where you went. There we go. I appreciate the question. I'll stop taking notes for you. I was feeling guilty that you disappeared somehow. Kenneth, Tad, Mike, Ron, is there anything else? We're pushing 3 o'clock. Is there anything else you'd like to end with today? And just as a quick reminder for everybody else, we're going to put all of the content from today's call as well as a recording at eoraleigh.com/coronavirus. You'll find links for our next 4 webinars at that same location, and feel free to pass it on to your chapter and community members. Again, Amy, thank you for helping set these up and making these all possible. But Kenneth, Tad, Ron, Mike, anything else you'd like to end with today?
So I'll let Kenneth finish, but I'll just say that if anybody has further questions that they want to address offline, please send either me or Mike Lord or Ron Rogers an email, based on subject matter area. Please know that we're going to have to run conflicts before we can actually give you specific advice. But we're happy to give you a half-hour consult free in any event.
Yeah, on behalf of High Rock Partners, we're glad to do the same thing. We don't have the conflict issue, obviously, but send me an email and we'll schedule a time. Matt and team, we really appreciate the opportunity to have participated today. So thanks so much.
Perfect. I believe Todd has had to move on. So again, thanks everybody for attending. There's a quick poll if you can take it on your way out. Kenneth, Tad, Ron, Mike, thank you so much. Incredible information. Really hope we can do this again sometime. Thanks so much.
Thank you.
Great job,
Appreciate it.
guys. Thank you.
Bye-bye.
Take care, guys.